All right, everybody, we are interrupting the chat we had earlier with Ambassador David Sheffer because we want to bring you the latest developments in Donald Trump's criminal trial. The judge has adjourned the court through the holiday weekend after lawyers of the former president rested their case. So no more witnesses, despite earlier reports that the former president was considering testifying.
Yeah, so just a reminder, he's accused of falsifying records to hide hush money payments made in 2016 to cover up an alleged affair with adult film actress Stormy Daniels. And the argument is that he felt that if this affair got out, it would have an impact on his ability to win the election. So that's sort of the crux of it, that it's kind of a campaign contribution violation is what they're trying to argue. But the defense, Lindsay, really only called one witness, right? A lawyer, Robert Costello. He was sort of being described, and he described himself as a back channel route to the president for Michael Cohen. It's
to Giuliani.
To Giuliani, and then ultimately Giuliani to the president.
Just named the former president's personal attorney.
And this is happening at a period of time when Cohen finds himself a little bit on the outs. He used to be able to talk directly to Donald Trump, or at least call up Donald Trump's security guard's phone and get a message to. And now he's finding that there are two lawyers in between him and Donald Trump, and Cohen is not happy about that. Under cross-examination, Costello was presented with various emails suggesting or attempting to suggest that there was an awareness on Donald Trump's part as to what was going on in terms of the reimbursement scheme and all of that sort of stuff. But, you know, with all of these emails, there isn't kind of a direct statement. You know, the president knows about this. Donald Trump knows about this. Of course, you're never going to get kind of that smoking gun, if you will.
Yeah, that is really the central crux of the question, though, that the jury will be deliberating on. And to give you a little bit more information about where we are here in this case, so the defense, as Anne-Marie mentioned, really only called that one witness, Costello. He was cross-examined today, and the defense rested their case. So what has the judge said? Well, they will now have closing arguments on Tuesday. Well, we have the holiday weekend. And also we should note that tomorrow, Wednesday, the judge is going to deliver the jury charge, next Wednesday, after closing arguments, and then the jury will begin deliberations. But today there will be a charge conference in which the two sides will be able to sort of hash out information related to the jury charge. A huge portion of this will be jury instructions and exactly what they will need to be focused on in their deliberations.
So we're going to bring in CBS News legal contributor and Loyola Law professor Jessica Levinson to kind of talk a little bit about where we are at right now. Jessica, only one witness called on behalf of the defense, this attorney, Robert Costello, who already, upset the judge already. So I don't know how that's going.
And we know that in a sidebar from the transcript.
Right, exactly. The judge didn't like some of his facial expressions, his sort of huffing and puffing, and the judge, cleared the court in order to kind of give him a piece of his mind. So can we just talk a little bit about what this who this guy Robert Costello is, and what the cross-examination was all about, what the prosecution was trying to prove with him?
So the defense was using him to try and prove, I think there was an allegation that Michael Cohen said to him, Trump knows nothing about these payments. And so the idea is, and this has been part of the defense's strategy all along, to separate out the payments that Michael Cohen made to Stormy Daniels, to separate Trump from them. Because obviously for the criminal conviction, you need to connect Trump to those payments, to the allegedly false reimbursement scheme, and to the purpose behind those payments. And so Robert Costello was there to try and break that connection. I don't know that he was particularly effective at doing that. You have a witness on the stand who's sighing, who looks exasperated, who frankly looks, I think, somewhat recalcitrant. The jury sees that. The judge sends the jury out of the room so he can essentially reprimand Robert Costello. And while the jury doesn't hear that reprimand, I think they know what's happening. They know why they're being cleared out. And the jury is watching the judge. The jury is identifying with the judge. The jury is trying to figure out how things are landing with the judge. And so I don't think that was a fantastic moment for the defense. But let's remember that the defense, and I know I always say this, but has a very, very different role than the prosecution. Prosecution has to build that whole house from scratch, has to build up the whole story, has to make all the connections, and has to prove beyond a reasonable doubt that there was criminal activity. The defense has a really different role. It's just poking holes in that story. It's trying to push down one beam in that house. And frankly, just push down one beam so that one juror says, maybe he did it, but not beyond a reasonable doubt. So the defense can have a bad witness or a witness that's not that helpful, but can still put doubt in a juror's mind.
Then how important are these jury instructions that they're going to get? And also, Anne-Marie and I were talking before we went live with you about the instruction for the judge to say, okay, we're not going to do closing arguments until after Memorial Day weekend, and then the jury is going to get the case.
So I'll focus on the first part, if that's okay, the jury instructions. And I do think that they are very important. They're always important because that's what the jurors are looking at. They're not looking at, do we like this person? What kind of tie were they wearing? They're looking at the instructions. That is literally their job, to try and look to see whether or not, based on the facts that were presented to them, they think that there was criminal activity here. And I think the jury instructions are particularly important here because it is a complicated case. And we've all been talking about this case for almost a year now, but it takes a moment to explain it, because step one is, do we think that Trump falsified business records? But that, again, is just step one. Step two is, if yes, were those business records, which is, again, the payments from Trump to Cohen, were they falsified in order to commit or conceal another crime? So you have to find that the former president formed intent, and that was intent to commit or conceal another crime. And then you have to instruct the jury on what that other crime is. It looks like at this point, the prosecution is focusing on a New York elections code that says it's unlawful. You can't enter into a conspiracy to try and promote a candidate or try and degrade a candidate in an unlawful way. I'm paraphrasing the election code. But all of that is complicated, and it really will be key for the sides to agree on how the jury will be instructed.
I think you're sort of talking about what Lindsay and I have talked about, and people said initially about this one case compared to all the other legal challenges that the former president is facing, is that this seemed like the weakest case. And part of it has to do with it's not about falsifying business records, though that could be a crime. He's not actually being charged with that. He's being charged with something connected to that. And so it's a complicated leap to explain, I think, to jurors why he would be charged with a secondary crime and not charged with an underlying crime. I might not be using the right phrasing, but do you get what I'm saying, Jessica?
Right. So this is not just a straight up falsification of business records. And I think, as you point out, that's part of the story. And so that is just the threshold here. But Anne-Marie, I think you're exactly right that it takes the fact that you have to link that first crime onto a second crime, explain how they're linked, explain what that second crime is. There's a lot of work here for the jury. That doesn't mean I think that this is a case that's absolutely unwinnable, but it means when we looked at all of the criminal cases that are pending before the former president, let's remember there are 2 election interference cases, one in Georgia, one federal case. There is a criminal case in Florida dealing with the allegedly unlawful retention of classified documents. This is the case that I think is the only case that will go to trial before the election. And it's the case that I think feels the least important to people. And because it sounds like it's kind of just a paperwork error. And it's a case that arguably is hardest for the jury.
So let's go ahead and bring in CBS News investigative reporter Graham Cates, who is inside the courtroom, has been throughout this entire trial. So, Graham, just give us a little bit of color of what you saw in there today and who is in there.
Sure. So this was the last hour or so of cross-examination and then redirect of the defense witness Robert Costello, and it was kind of similar in testiness to what happened yesterday. Although Costello himself kept himself under control, he didn't jeer the judge or seem to make any comments about sustained objections, so they were able to get through it without excusing the jury. But prosecutor Susan Hoffinger really tried to hone in on some of these communications that Costello had with Michael Cohen in 2018, where he talked about being a back channel to President Trump, and most importantly, she focused on one part where he said that that Cohen had friends in high places, and she said, "Friends in high places, you're talking about President Trump, correct?" And Costello paused for a moment and said, "Yeah, I think that's reasonable to conclude. That's what I was relaying to Michael Cohen."
And so what was kind of the focus of their cross-examination? Was it to kind of somehow solidify that connection to Donald Trump, or was it to focus on his dislike for Cohen? Because there seemed to be a lot of emails and conversations about them trying to get Cohen on the same page, that there was a concern that he was, not in line with the program, if you will.
Yeah, so Cohen had said that he believed he was the subject of a pressure campaign to keep him on the same page as Trump and the rest of Trump's team. And that was what they were kind of trying to bring this back to. Remember, there had been days of withering cross-examination, hitting Cohen on his lies and his credibility. And so here was the opportunity with a defense witness to refocus the jury on what Cohen believed happened to him, which was that Trump and his allies, he said, pressured him to kind of cover up this whole thing, right? To cover up issues with campaign finance and to be on the same page through this back channel to Rudy Giuliani. And Cohen had said he never really trusted Costello for that very reason, because he was so close with Giuliani, who at the time was representing Trump, and felt that anything he said to Costello would end up in Trump's ears.
Fred, what's the latest with Trump's team's motion for a dismissal before the case goes to the jury? I mean, you were reporting on this, that, saw in the transcript when the courtroom was clear that the judge essentially was saying, you think his lies are irrefutable, meaning Cohen's, correct me if I'm wrong. Do you think he's going to fool 12 New Yorkers? What's the status of that motion?
Yeah, so the judge hasn't ruled on that yet, but look, this isn't the first time they've asked for a mistrial. Whether it was seeking to drop the charges, to delay the trial, to adjourn it, and then, of course, for mistrials. This is the latest in more than a dozen times when they've tried to halt this case. And you quoted the judge as he responded to it yesterday. It didn't sound like he was very amenable to now, at this stage in the game, declaring a mistrial, but he hasn't yet ruled on it.
All right, Graham. And Jessica, I want to ask you about this. As you know, Donald Trump has said over and over again that he wanted to testify, but then he sort of suggested that the gag order would limit him from testifying at one point, which we know that's not what the gag order is all about. But ultimately, he chose not to testify. I don't suppose that surprises you at all.
No, it always relieves me when we can look back at the tape and I'm right. And this was one of those situations, but it wasn't just me. And that's the reason that I bring this up. It was, I think, virtually every legal expert said there's no way. And we always need to focus on what the former president says outside of a courtroom when he's not under oath versus what he says or doesn't say when he is inside a courtroom. I think this would have been a huge loser to put him on the stand because, one, let's remember, most criminal defendants don't take the stand for some obvious reasons. It subjects them to cross-examination, which, depending on the defendant, can be potentially hugely risky. So what I think the former president would have had to assume here is, one, that he was going to lose the case, and two, that he could potentially win by taking the stand. One of the things that I think went through the former president's mind, to the extent he really was ever thinking about testifying, which I'm frankly not convinced about, is I think he really watched what happened to Michael Cohen during those days of cross-examination, and how he really was subject to a grilling, as he should be. This is an adversarial system, how Michael Cohen was subject to a grilling on cross-examination. And I think part of that was telegraphing to the former president, that's what would happen to you. And let's be honest, thinking about somebody with baggage, the former president does have issues that he will be brought up on cross-examination that I do not think would be helpful to his case.
Jessica, given what you know about juries, how crucial, how much does it come down to what is said during closing arguments?
So closing arguments are, I think, again, really important in this case because it is a difficult case, because it's a case where you want to put everything together for the jury. So I think it's particularly important, obviously, for the prosecution to be able to make all those links in the chain, not just in terms of the evidence, but then tying it all to the former president. Now, arguments are not evidence. So arguments are just the attorney's way of and chance to say, here's everything you heard. I told you you were going to hear this. I told you X, and now I delivered on it. So is it key here? Is it absolutely the thing that everything's going to turn on? I think it's difficult to know. There are some jurors who may have already made up their minds. But again, I think for the prosecution, because it's a difficult case, they do really need to walk the jury through. Turn right here, turn left here, go straight here.
Really interesting. Jessica, Graham, thank you so much.